Good morning, my learned friends. My honour, Mr. Headley Christ. My name is Nicholas Hemming and I'm going to be giving a presentation on the nature of direct effect for directives. Now, to start with, what are directives? Now, directives are instructions to member states to enact a law. They seek to resolve conflicts where there's differences between national law and EU law. They seek to provide a form of remedy. I have a quote here from Article 288. It states it shall be binding, but it shall at the same time leave choice to the national authority of how they wish to implement it. So what are the limitations of directives? Like I said before, the member states, they at some discretion how they wish to implement it. These directives can be in very general terms and therefore not sufficiently precise to allow for national judicial enforcement. They do not automatically have direct effect. This is to say they do not automatically become part of national law. So the second part of the question is, what is direct effect? Well, direct effect is, as we said previously, does it automatically become part of national law? For this, they must meet the criteria. The directive must be precise, must be unconditional, the absence of discretion, and not require any implementing measures. So can a directive have direct effect even with the absence of implementation by a member state? Well, we have three principles here. Two are established in Van Dun, and the third is Ratti. So I will firstly focus on the two conditions from Van Dun. Now, if we look at the case of Van Dun, it established that directives will be effectively enforced if individuals can rely on them. The useful effects of directives would be weakened if individuals cannot rely on them before their national courts. So to strengthen them, the individuals have to be able to rely on them. So that was the factual reason. Now we have the textual reason. I have Article 234 on the screen, but I think you'll find this is Article 267. This allows national courts to refer questions concerning any community measure to the European Court of Justice, and this includes directives. So this is to say that individuals indeed can invoke their directives before national courts, therefore they can rely on them. So we've discussed the criteria found in Van Dun. If we move on to our second key case, Ratti, this focuses on the principle of estoppel. This prevents the member state from denying a right of the binding of a directive. This is to say that if a member state fails to implement a directive for whatever reason may be, and the expiration date has passed for this directive, they cannot seek to deny a binding effect. Therefore, when the expiry date has passed, this acts as a trigger point for individuals to rely on this directive in a court of law. So just to recap, we have the criteria for directives again. They can be enforced if individuals can rely on them. Their usefulness would be weakened if they could not rely on them. And lastly, the estoppel principle. So how are directives directly effective? Well, it's been established that directives are only vertically directly effective. This is to say they can only be used against a member state and not against an individual. So we have the horizontal level and the vertical level. They can only be used upwards. They cannot be invoked against another individual. This is because the individual has to be a member or an organ of the state for the directive to be invoked. And we will discuss this in the next case to come, which is Foster and British Gas. Now, Foster was at the time held to be a nationalised industry. This is because it was subject to the control of the state, and it had special privileges which it was granted by the state, which goes beyond the normal rules which apply to business. Providing a public service is also another part of the criteria for businesses that are organs of the state. So just to recap, what constitutes a public body? It must provide a public service, it must be under state control, and it must have special authorization or powers which are being granted by the state. This criteria constitute what is known as emanation of the state. So to conclude, directives, they're useful key instructions which function as guidelines for national law. Where it is in conflict with EU law, it helps empower individuals and seeks to expand their rights which they may not have under their national law but may have under EU law. Occasionally, a provision initially is held to be invalid or incapable of direct effect, only later to impose an obligation after being reviewed by the ECJ. So, if we look at our fictional scenario, Mrs. Grace DeVille, does she have a right to invoke the directive against Groves Farm? The directive is clear, precise, and unconditional. Note the word banned here is very clear. However, Agripest is a company, but we have not established if it is under control of the state. And we've already established directives only have vertical effect and not horizontal. Therefore, if Mrs. Grace DeVille can show that Agripest is an organ of the state, she will be able to invoke the directive against them. If she can't, then I'm afraid she cannot rely on the directive under EU law. So just to conclude, my name's Nicholas Hemming and I hope you've enjoyed and it's been informative to you all. Thank you very much.